Hello, everybody, and thank you for downloading this Collier Bristow podcast talk in our series about employment and related issues, related challenges facing businesses at this time. We are now seeing increasing numbers of employees who've been working from home, returning to work in offices and other workspaces, as well as technological developments that have the capacity not only to make the workplace more efficient, but also give rise to concerns about their impact on workers. My name is Patrick Wheeler, and I head the data protection and intellectual property teams in Collier Bristow. And I'm joined by Patrick Kilgallon, who is an associate in our employment team and who has been following these developments with close attention throughout the pandemic. So, Patrick, I gather you're going to do a separate talk on the impact of vaccines and how that can how that can impact on both employers and employees. So moving on from that, one of the big issues, it seems to me, is the question of employer monitoring of employees. So if an employer is minded to keep their workforce working from home, what arrangements do you suggest that they should put in place?
Thank you, Patrick. So just as a bit of background to the ongoing working at home arrangements. So even a month after the pandemic started back in April 2020, nearly 50% of people were already working from home. It's a radical change in working arrangements. And I think we all expect that this will continue, if not at current levels, but at some form going forward in the future. And that's backed up by recent surveys that indicate about 70% of employees would like to continue to work from home for at least one day a week. So as you see from that, home working is likely to continue permanently in some form in the future. Now, that might be for financial reasons. Employers can save, thousands, tens of thousands of pounds by not having office space in the same way, or social reasons. Commuting to work for an hour and back each time every day, that saves a lot, helps, family life, social life. That's important for a lot of people now. However, even though this has been going on for over a year now, home working, there's still a perception from employers that employees are simply binge watching their favorite Netflix series all day. They're tucked up in bed watching The Crown. And so consequent on this, there's a variety of employee monitoring clauses. And now that can involve anything from checking whether employees have logged on to their internal IT systems, spot checking emails, all the way down to the more intrusive monitoring of keystroke monitoring, and the sort of top tier of the most extreme is monitoring movements via webcam.
Yes, I must say I find that a little bit odd. It doesn't certainly square with my experience. I think, if anything, employees working from home, they might work more flexibly in the sense that they're not working necessarily from 9:30 till 5:30, but it seems to me that they are putting in just as many, if not in some cases more hours than usual. So that is a little strange. But when you mention employee monitoring, what exactly do you mean by that?
So it's quite broad, and I've just sort of touched on it a little bit there with the examples, but it's basically a term just used to capture any form of surveillance of employees by their employer. So it captures all those things that we just mentioned: keystroke monitoring, website access, etc. And that information can be gathered for a variety of reasons by employers, from monitoring capability and performance to misuse of company property to ensuring security of confidential information.
Okay, and if you're an employee, how do employees typically feel about this? Is it something accepted, or is it something that actually creates a lot of resentment and resistance?
Instinctively, as I think you'd imagine, Patrick, is that most employees just aren't fond of the idea of being monitored. Particularly, as you allude to, I think most employees have taken to the working from home quite well. And I certainly feel myself that I stay logged on longer than I would in the office. I think the critical thing that employees are disliking about this is that you're importing a work environment to a very private space, particularly for most people within their own bedrooms. This is an instinctive feel. It's quite, 1984-esque, and that they don't want their work life completely taking over their private space. And this is backed up by a variety of surveys, but I'll just pull a YouGov one from the end of 2020, is that 80% of employees are uncomfortable with any form of camera monitoring. 74% of employees would feel uncomfortable with electronic tracking and wearables. 67% would be uncomfortable with keystroke monitoring, and just under half said that the introduction of monitoring software would damage their relationship with their employer and their manager. And this rose to a further 62% for young people. So clearly there's a strong feeling of mistrust towards employee monitoring from the employee side.
Yes, that's interesting, but and it's particularly interesting, I think, that the kind of monitoring has an impact on the way that it is perceived by employees. So I think that's something definitely for people to bear in mind. And one would assume that if you can make it less rather than more intrusive, that would prove to be more acceptable and would lead to a better relationship.
Yeah, indeed.
But moving on, what exactly is the legal framework for these monitoring systems?
So we're looking at a variety of different legal frameworks here. It crosses over between employment law aspects, human rights aspects, and obviously data aspects. Taking the data aspects first, you've got the General Data Protection Regulation. Everyone knows this is the GDPR and the Data Protection Act. So this element covers electronic forms of surveillance that involve the processing of personal data. So that's the first aspect. Second aspect is the human rights aspect. Now, Article 8 of the European Convention on Human Rights states that everyone has the right to respect for his private and family life. Now, this isn't technically an absolute right. It has exceptions in accordance with the law that's necessary in a democratic society, and a variety of sort of get out cards are available there. You've got the interests of national security, you've got prevention of crime and disorder, protection of health and morals, and also the protection of rights and freedoms of others. So the convention is imported into the UK law by the Human Rights Act. And although only public authorities and bodies are expressly subject to the Human Rights Act, the courts and tribunals must, so far as possible, interpret the legislation consistently with the relevant human rights. So it's going to be relevant to private or public sector going forward. Now, for this area, the case law tends to focus on the question of whether the employee had a reasonable expectation of privacy in relation to the communications in question. If they did not have an expectation of privacy, then Article 8 will not be engaged. If they did have an expectation of privacy, then Article 8, the respect to private life, will be engaged. And finally, the third element of this is the employment aspect, the Employment Rights Act and the Equality Act. These will be relevant if evidence gathered via employee monitoring is then used to dismiss an employee. Now, employees with a variety of protected characteristics, race, gender, sex, disability, they might argue that they've been unlawfully discriminated against if the employee monitoring has unfairly targeted them. And that can pose a whole host of issues down the line for employers.
Yes, and certainly from my own area, the data protection area, there are concerns here because, of course, one of the key principles of the UK GDPR and European GDPR is that of data minimization, which means that you should only be collecting and processing the absolute bare minimum of data that is necessary for your business purposes to do. And there are some very strict rules about video monitoring in particular, so CCTV and monitoring of that nature, which again is all designed to make sure that the bare minimum is collected. And another concern here, of course, is that it's not just standard personal data, but also special category data. And special category includes things like health characteristics, biometric data, data relating to sexual preferences. All of these things, the monitoring that is carried out could stray into these areas. And that imposes much, much higher obligations on employees as data controllers to make sure that they've got the correct legal basis for collecting and storing this information. And furthermore, that they've got the right security in place so that it doesn't leak out or it's not used for purposes other than those that have been specifically identified to the data subject. We've talked a lot about different kinds of monitoring. Perhaps we can just return to that in a bit more detail. Exactly what sort of monitoring can be undertaken?
Yeah, so unfortunately, in this aspect, there's no definitive, one size fits all guidance. It will vary from business to business, from, as you just mentioned there, the type of data that's being collected. So the balance that is there to be struck is protecting the business's legitimate interests and also protecting the employee's right to privacy. The key question is going to be whether those proposed measures are proportionate to the risk that it is attempting to mitigate. If a less intrusive form could achieve the aim, then this should strongly be considered and used. And just as a touchstone example of sort of the other extreme, where you probably can be a little bit more intrusive, is that the FCA, the Financial Conduct Authority, have been quite clear that during the working from home period, that financial services firms were to put in quite vigorous oversight on traders, obviously for the economical and regulatory risks that can come with the work that traders do.
Yes, so that's another interesting aspect. What is appropriate monitoring is likely to vary depending on the nature of the business that the employer is undertaking. So I touched briefly on GDPR, but perhaps we can come back to that in a bit more detail. What are the steps that employers need to bear in mind in order to make sure that they are compliant with UK and EU GDPR?
Yeah, so sort of in a general sense, under GDPR, data must be processed lawfully, transparently and fairly. It must be collected for specified, explicit and legitimate purposes, and it must be limited to what is necessary only for those purposes. So employers, they must have a legal basis for processing the data. It's not normally possible to rely on consent as a valid lawful basis, because there is a very strong difficulty there in establishing that the consent has been freely given due to the inequality of bargaining power and the power dynamics between employee and employer.
Yes.
So the more intrusive the monitoring, the harder it is to demonstrate the balance with the employer's legitimate interest. One route for employers to look into whether it is legitimate is that they can use LIAs, which are legitimate interest assessments, and that will demonstrate the decision-making process and the justification for processing on the basis of those legitimate interests. So not only does this provide good evidence that the employer has considered its legitimate interests and go through its decision-making process, it allows it to cast its mind to actually considering what the expectations of the employees are around the monitoring and any impact. Sort of coupled with that, you've also got data protection impact assessments, which must be carried out when the processing is likely to result in a high risk to the rights and freedoms of individuals. This includes systematic and extensive profiling with significant effects, large-scale use of sensitive data, and also public monitoring. Though some monitoring policies don't necessitate a data protection impact assessment, I think it's quite good practice for employers to carry these out. They allow the identification of the purpose behind the monitoring and the benefits consequent on the monitoring. It allows employers to highlight any adverse impacts of any monitoring arrangement, and then enables them to consider alternatives. So it'll allow an employer to just look at whether this particular monitoring is actually justified.
You talked about the difficulties of obtaining consent as a valid legal basis for processing. The fact that the employer's legitimate interest has to be balanced against the employee's interests before that can be a legal basis. How about using the contract of employment as a legal basis for processing?
Yeah, so the contract of employment normally have highlights of the data that will be processed in there, and it should hopefully break down the categories of data that will be processed and how it will be processed. Ultimately, depending on the extent of that processing, it will still depend on whether that employee's consent or the contractual consent there will justify it.
So I think what that shows is, well, for one thing, one size doesn't fit all. The assessment, the analysis is going to be different, again, for employers in different sectors, and indeed for different sizes of employers, for different kinds of businesses, for different needs of individual employees. So this is something that you really need to consider with a great deal of care, and to be able, if there is a complaint in the future, to show how you've reached your decision, and to be able to show that there has been careful consideration and a justification for the conclusion that you've come to. So we focused so far on the concerns for employers here. But looking at it from the employee's side, if an employee perhaps feels that the employer has not taken the appropriate steps, what are the steps, what are the claims that an employee might have if they feel that their data is being misused?
So from my employment law perspective, there's a variety of claims that could end up occurring if this takes place. So if an employer is found to have used the information that has been unlawfully collected, i.e. in breach of the data protection legislation, there is a good chance that employee could have a claim for breach of mutual trust and confidence with the employer, breach of Article 8, and these can then filter down into the employee having a claim for constructive unfair dismissal or just constructive dismissal. So discussing the breach of the implied term of trust and confidence, that's generally established that an employer must not, without reasonable or proper cause, conduct itself in a manner that's calculated and likely to destroy or seriously damage the relationship of trust and confidence between the employer and the employee. Breach of that could lead to a constructive unfair dismissal scenario. And that basically means that if the employer is guilty of conduct, which is a significant breach going to the root of the contract of employment, that is, then the employee is normally entitled to treat himself as being discharged from any further performance. If he does treat himself as such, then the contract is deemed to have been terminated by reason of the employer's conduct, i.e. he is constructively dismissed. Now, if the employee is able to prove that they've been constructively dismissed, and this will depend on whether the unlawful data gathering by the employer has been severe enough to go to the root of the contract, if they can claim that, there'll be a claim for wrongful dismissal, and also if they have the requisite 2 years continuous service, also a claim for unfair dismissal. Now, for employers, in reality, it's probably quite difficult for the employer to defend the fairness of its unlawful monitoring and defend and justify that to bring itself within the range of reasonable responses that a reasonable employer would have done. And it's quite likely that an employee would have a quite strong claim for constructive unfair dismissal in these circumstances. Now, moving on to the data protection element, sort of outside of that, the employees can make complaints to the Information Commissioner. Now, this is quite a hefty one for employers because it can result in fines of up to 4% of global annual turnover or 17.5 million in a fine, whichever is higher of the two of those. Also, potentially more damaging, depending on the size of your business, the ICO has also got the power to name and shame those in breach of data protection law. And now, at the moment, that's really not a good look on companies, with people becoming more acutely aware of their personal data and how their personal data is used. There's an immediate distrust, I'd say, sort of in the population now for giving away their data. People are very keen, for example, when they go on websites and they're asked to accept cookies, they now disapply all the ones they can. It's more at the forefront of people's minds now.
Yes, I think that's definitely true. There has been a growing awareness, certainly since GDPR came into force, of the rights of individuals, which is a good thing, certainly if you're an individual, and it has forced businesses to become much more aware of their obligations. And as you say, complaints to the Information Commissioner are a very bad thing for any business, for any employer. It takes an enormous amount of time. It's an official investigation. You have to comply with their requests. It can lead to naming and shaming, as you've mentioned. It can also lead to a range of possible enforcement measures. The fines, obviously, are the sort of the nuclear option at the top of the list, but there are a number of other measures less serious than that, which are nevertheless quite intrusive and quite problematic for businesses to comply with. Is for example, having to change their policies and procedures, having to undertake to train and inform employees of how these policies have changed. So that there is a lot of work, and getting it wrong in the first instance can mean that the process of getting it right is expensive and time consuming. So it does really pay to put the time and money into getting it right before a complaint is raised, and then you're in a much better position to deal with it if it does happen. Something you haven't mentioned, which is another possibility and is getting wider publicity, is the possibility for individuals, and this would include employees, to bring individual claims for damages for misuse of their data and for breach of privacy, breach of confidence. So all of these are possibilities. I have to say that those claims are not simple. They're not straightforward. There has been some pushback. There's a case going on at the moment involving Curry's PC World and an individual who's brought a range of claims against them arising out of a data hack. So it wasn't actually the fault of the business in that case. And the judge there has been quite careful to analyze what the possible grounds of complaint are and to say that you really have to demonstrate a fault, a lack of the proper controls and procedures being carried out by the business in order for those individual claims to go forward. But if there is fault, then potentially those can be quite serious claims, particularly if there are large numbers of people affected. So that's something not to be dismissed and thought of as of no importance. Okay, so having sort of started talking about legal cases, I understand there are quite a few European Court of Human Rights cases on employee monitoring. Do you just want very briefly to run through some of the more significant ones of those, Patrick?
Yeah, no problem at all. So, as you can imagine, with the working from home situation across the UK and across Europe still being quite new, and cases take a while to filter through, there's no direct cases in relation to Article 8, i.e. the right to privacy in relation to employee monitoring. However, I think what's quite useful in these cases is they give some various principles that I think you can extrapolate, and it would be a very similar situation in the UK case law. So one of the main cases that I'd like to touch on now is called Barbulescu versus Romania. Now, facts of this case are that an employer had a policy, and that policy stated that computers used for work couldn't be used for personal purposes. However, the issue in this case was that the employer was not specific in indicating the nature and the extent of the monitoring, or indeed that the employer could actually access the content of the communications. The employee actually only became aware that the employer could monitor the content of the communications during the disciplinary process that led to his dismissal. Now, this rumbled on through the courts in Romania and then went up to the European Court of Human Rights. And the Grand Chamber of the European Court of Human Rights decided that Article 8, the right to private life, had actually been breached. Now, it was the employer's failure to expressly advise that the policy involved the actual monitoring of the content of the personal communications. So the correct balance in this situation between the employer's interests and the employee's right to privacy hadn't quite been justified. Indeed, the court has made comments throughout this case that I think are quite helpful in steering employers what can and can't be done. And they did note quite strongly that an employer's instructions cannot reduce private social life in the workplace to zero. So just because someone's at work doesn't mean you can set their rules about what they do for every minute of every day. The Grand Chamber also set out a variety of factors. I've picked out a couple of them here that should be considered when assessing whether workplace monitoring is compliant with the right to privacy. So one of the main ones that I think is important is the employee must be notified of the possibility that the employer might take measures to monitor correspondence or communications, and also must be aware of the implementation of these measures. Now, this is a running theme in all the cases, and the commentary on this is this transparency and openness and consultation with employees is critical. That's further bolstered by the second factor they highlighted, is that the extent of the monitoring and the degree of intrusion into the employee's privacy is critical. So if you're monitoring simply the flow of communications, when emails were received, when emails have been sent, that's one level. But when you stray into the context of monitoring their actual content, you need a greater justification for that. That logic also applies that if you monitor communications for just an hour of a day versus weeks, you can see there's a scale that slides there for the justification that you'll need each time increasing. Third critical factor is that the employer must provide legitimate reasons to justify the monitoring of the communications. Fourth is whether it would actually have been possible to establish a monitoring system via less intrusive methods. having people read the personal content of private emails at work is very extreme. If you're trying to achieve a certain goal, whether it's monitoring capability and performance, there are a variety of other methods that can be deployed in that situation. It doesn't necessarily have to lead to the employer reading the minutiae of an employee's personal life. And finally, on this case, the fifth factor is that the court was quite keen for the employer to have adequate safeguards in place, just so as to ensure that excessive intrusion doesn't happen all the time. And if they did want to review the content of communications concerned, they should notify the employee of that. So that's one of the, I think, a very important case. It gives a variety of principles that we can look at and use those to move forward. Now, in a second case that I'm going to discuss now, Garramakana versus the United Kingdom, this was it was an employment tribunal case that ended up going to the Employment Appeal Tribunal, then all the way up to the European Court of Human Rights. And now in this case, the European Court of Human Rights agreed with the Employment Appeal Tribunal that the employee had no reasonable expectation of privacy in material that had been seized from his mobile phone during a police investigation. So once that material had been seized by the police, it was then subsequently passed to his employer, who then used it in disciplinary proceedings against Mr. Garramakana. The crucial difference between this case and the Barbulescu case, where in Barbulescu they had no idea what the employer was doing, they had no idea the employer was actually monitoring the content. In the case we're currently talking about, Garramakana, he was put on notice by his employer for over a year that the conduct was unacceptable after a complaint by a colleague. So the court basically considered that he could not have reasonably expected that after that date that his communications linked to these allegations that had been ongoing for a year would actually remain private. And just on to now the third of the four cases that I think are quite interesting to look at. Is Argus Media Limited versus Halim. So this was a case where an employer sought to enforce post-termination restrictions, and the employee instead argued that he'd been released from these post-termination restrictions because the employer had repudiated the employment contract by reading personal emails in his inbox. So this is a case concerning constructive dismissal and repudiatory breaches that I discussed earlier. It's all about, the key is whether, is an employer justified in these circumstances to monitor the personal content of these emails, and if they are justified, does it provide a legitimate reason for an employee to claim constructive dismissal? Now, in this case, the court actually disagreed with the employee. The key element of why it said this was that in the circumstances of the case, the employer had authority to monitor and review the use of employees' IT systems under their computer policy, which the employee had signed. So it's that notice, the employee's been put on notice that this data was being monitored. Now, it held the action of the employer here was not an illegitimate interference with the Article 8 right to private life. However, it also held that even if there had been a breach of privacy, that in the particular circumstances, such a breach was not one that was likely to destroy the relationship of trust and confidence. So it should not always be assumed that just because there's been a data breach, that it should then immediately leap to a justification that breaks the trust and confidence between the employer and employee. It's got to be a fact-by-fact, a case-by-case analysis, looking at the facts and merits. And finally, just very briefly, is Copland versus the United Kingdom. So in this case, the court considered the monitoring of employees' telephone, email, and internet usage. And the upshot of this was that the European Court of Human Rights considered that Article 8 would be infringed where there was no IT policy in the workplace and the employee was told they were not being monitored. So this is just a lesson for employers to make sure you have that IT policy in place and make sure it's clear to employees that that this policy is in place, and that is a great way to bolster your position that they were aware and that the monitoring was legitimate in this sense.
Well, thank you, Patrick. That's, I think, been really helpful to run through those cases and the key principles. I mean, some of the things that seem to me to come out of that are the critical importance of keeping engaged with your employees, consulting and keeping them informed of what you're doing, and explaining the basis for it as well. So it has to be reasonable, there has to be a good justification. And if you do that, then the likelihood that these monitoring steps are likely to be regarded as reasonable by the courts is greater. I think something I just wanted to add here as one of our concluding thoughts is that employers and employees need to be aware that one of the rights under the UK GDPR is for an employee or for an individual, the data subject, to put in a request for the data that an employer holds about that individual to be disclosed under a data subject access request. And these are being increasingly used in disputes between employers and employees. And the employer's obligation is to comply with that. They can't refuse. They can't say, oh, this is just a tool, a way to help this individual in their potential claim against us. The employee's motive in putting in a subject access request is irrelevant. You do have to comply with it as an employer. You have a limited time in which to do so. And although there are grounds on which you can withhold certain data, they are quite limited. So be aware that this is something that is likely to be used, and preparing yourself as an employer so that you are in a position to be able to deal with it quickly and effectively, I think is very, very important. So, Patrick, any sort of final thoughts that you wanted to add to the discussion?
Yeah, I think you're completely correct there. That one of the critical messages that comes through both the case law and the guidance in this area is keeping employees involved and aware and being open and transparent with them about the developments that are going on. I think also it's that providing and having put your mind to the task of considering whether it is justified and whether it is proportionate to what you're trying to achieve. It's still quite a fresh area of law, and it's hoped that there'll be some more case law going forward or further guidance on actually what these limits are, what employers should be looking at the moment. Because although gleaning principles from case laws is useful, it'd be much easier with some harder guidance on limitations.
Very good. Well, thank you to everybody who's listened to this podcast. I hope you found it interesting, informative. Maybe it's raised some questions in your mind. If there are any issues that you would like to discuss, anything that you would like to speak to us about, our contact details are on the website, so please do get in touch. Our next podcast is going to be on issues relating to artificial intelligence, and we very much hope that you'll join us for that podcast as well. Thank you and goodbye from me, Patrick Wheeler, and from
Patrick Kilgallon. Thank you very much.
Thank you. Bye-bye.